Before we begin, a quick and important disclaimer. The following content is provided strictly for educational and entertainment purposes. It does not constitute legal, financial, or professional advice. Divorce laws, filing procedures, and court requirements vary significantly by state and jurisdiction. The information regarding Divorce 661 and rural legal trends is based on historical data and general observations of the legal landscape in 2026. Viewers are strongly encouraged to conduct their own due diligence and consult with a qualified attorney or licensed legal professional in their specific area before making any decisions regarding their marital status or legal filings. In the heart of America's rural landscape, a silent crisis is unfolding that the national headlines are completely missing. While the overall U.S. divorce rate has actually seen a steady decline over the last decade, hitting a 50-year low in some metropolitan hubs, the numbers in our small towns and farming communities are telling a radically different and much more somber story. Statistics from 2024 and 2025 show that rural counties in states like Wyoming, Mississippi, and Oklahoma are now seeing divorce rates nearly double those of urban centers like New York or Boston. But there is a specific modern phenomenon known in the legal underground as Divorce 661 that is changing the game for rural couples. It is a process that promised a path out of the isolation, but for many, it has become a complex maze of jurisdictional traps and financial pitfalls. If you live in a community where the nearest courthouse is a 2-hour drive away, and everyone knows your business before you do, the traditional rules of separation don't apply to you. Today we are breaking down the wall of silence. This deep dive is designed to solve the most pressing problem facing rural families today: the lack of accessible, specialized legal information in an era where one-size-fits-all online services often fail those outside the city limits. We are going to explore why rural marriages are facing unique pressures in 2026, from the volatility of agricultural markets to the rise of gray divorce in aging small towns. Most importantly, we will dissect the mechanics of Divorce 661, a term often associated with specialized document preparation and uncontested filing strategies, and show you how people are successfully navigating the system without losing their land, their legacy, or their minds. To understand why this matters right now, we have to look at the rural divorce penalty. In a major city, you are a number in a crowded family court system. There is a level of anonymity that allows for a clean break. In a rural community, your divorce is a public event. It affects the local economy, the school board, and the social fabric of the entire town. Historical trends show that rural couples often delay filing for years longer than urban couples, not because the marriage is better, but because the cost of going public is too high. This delay often leads to what sociologists call the pressure cooker effect, where by the time a couple finally reaches the courthouse, the emotional and financial stakes have reached a breaking point. Let's talk about the data behind this shift. As of May 2026, the crude divorce rate in the United States sits at approximately 2.4 per 1,000 people. However, when you zoom into rural census tracts, that number spikes. For example, in parts of the South and the Mountain West, we are seeing refined divorce rates of 18.7 to 19.9 per 1,000 married women. Why? One major factor is the economic monoculture of small towns. When the primary industry in a town, be it coal, manufacturing, or a specific type of farming, takes a hit, the domestic stress follows immediately. Unlike urban areas with diverse job markets, a rural economic downturn leaves couples trapped together in a home they can't sell, in a town with no other jobs. This brings us to the rise of Divorce 661. For the uninitiated, Divorce 661 began as a specialized service model, most notably in California, designed to streamline the uncontested divorce process. It was built for people who realized that the traditional way of divorcing, hiring two aggressive lawyers to fight over every tractor and bank account, was a recipe for mutual destruction. In rural communities where legal resources are scarce, this model of summary dissolution, or documented assistance, has become a lifeline. It focuses on the default with agreement pathway. In this scenario, one spouse files the petition, and if the other spouse is in total agreement, they don't even file a response. This saves the couple hundreds, sometimes thousands, in court filing fees and prevents a public contest in front of a judge who might be your neighbor's cousin. However, the 661 model in 2026 isn't just about paperwork. It's a strategy for privacy. Case studies from small-town jurisdictions show that the more paperwork you can complete behind closed doors, the less discovery becomes part of the public record. In a rural setting, discovery, the process where both parties must disclose every asset and debt, can be weaponized by local gossip. By utilizing the 661 approach of pre-negotiated settlements, couples are keeping their financial skeletons in the closet. Let's look at a real-world example from a community in rural Idaho. A couple married for 22 years, owned a multi-generational farm and a small local business. In a traditional contested divorce, the court would have mandated a professional appraisal of the land, potentially forcing a sale to split the assets. This would have effectively ended a century-old family legacy. By following the principles of an uncontested 661 style filing, they were able to use a step-down spousal support structure and a land trust agreement. Instead of a judge deciding their fate, they used a legal document assistant to draft a plan where the land stayed intact. The outgoing spouse received a structured buyout over 10 years, and the community saw no disruption. But we have to be direct about the risks. Rural communities often suffer from legal deserts. According to recent 2025 reports, there are hundreds of counties in the U.S. with fewer than 3 practicing attorneys. This is where the 661 method becomes dangerous if not handled with extreme precision. When you move away from the traditional attorney-led model, the burden of due diligence falls entirely on you. If you miss a single disclosure regarding a pension or a piece of quasi-community property bought in another state before moving to your current rural home, the entire agreement can be set aside years later for fraud or mistake. Another layer to this deep dive is the social cost of rural divorce. In a 2026 study on adolescent adjustment in rural versus urban communities, researchers found that rural children often have higher protective factors, like mentors and safe neighborhoods, but they also face higher stigma factors. Because everyone in a small town knows the family history, the children of a messy divorce often carry that reputation into school and social circles. This is why the private settlement trend we are seeing this year is so vital. It's not just about money. It's about protecting the next generation from the fallout of a public legal battle. As we move through this masterclass, we are going to look at the step-by-step of how to determine if your situation fits the 661 criteria. Is your spouse truly amicable, or are they just quiet? Is your property community or separate? In the rural context, these questions have different answers than they do in the suburbs. We'll look at alternative assets, like water rights, mineral rights, and even localized agricultural subsidies, that standard online divorce forms often completely ignore. If you leave those out of your filing, you aren't just saving money on a lawyer. You're leaving your future on the table. This is part 1 of the most comprehensive guide ever produced for the rural American facing the hardest decision of their life. Stay with us as we move into the actual mechanics of the filing. Now that we have established the unique social and economic pressures of rural America in 2026, we must move into the engine room of the process. This is the stage where most people feel overwhelmed, but it is actually the most empowering part of a divorce 661 strategy if you understand the mechanics. We are starting with the gateway to the court, the residency requirement and the filing of the petition. This is not just a form you fill out. It is a jurisdictional claim that anchors your case in a specific legal venue. Imagine a man named Robert living in a remote county in Wyoming. It is March 2026. Robert and his spouse have decided to end their marriage, but his spouse moved across the state line to live with her sister in Colorado 3 months ago. Robert wants to file locally because he knows the court clerk and feels more comfortable in his home county. However, the first hurdle in the 661 process is the 6 and 3 rule. Historically, in many states, you must have been a resident of the state for at least 6 months and a resident of the county where you are filing for at least 3 months. If Robert files in his county, but his spouse challenges the jurisdiction because she has already established residency elsewhere, the case could be thrown out, forcing them to start over and forfeit hundreds of dollars in filing fees. In 2026, these fees have risen significantly in rural districts to cover the costs of new digital filing systems. You must verify your residency dates with precision. If you moved recently for a job in a different rural district, you might be in a legal limbo where you cannot file in either place until the clock runs out. Once residency is confirmed, the first official document is the petition. In the world of Divorce 661, we are almost always looking at a petition for dissolution of marriage based on irreconcilable differences. We avoid fault-based filings like adultery or abandonment because in 2026, the legal system is designed to move towards settlement rather than punishment. A fault-based filing in a small town is like pouring gasoline on a fire. It invites the court to look deeper into your personal life and increases the likelihood of a contested, expensive trial. The petition is accompanied by the summons. Think of the summons as the official notice that puts the world, and your spouse, on notice that the legal clock has started. It also contains standard restraining orders. In a rural context, these are vital. They prevent either spouse from selling off livestock, changing beneficiaries on insurance policies, or hiding equipment before the court can fairly divide the assets. Case studies from 2025 and early 2026 show a rising trend of something called asset bleeding. This happens when one spouse, sensing a divorce is coming, begins to sell off farm equipment or move grain into a neighbor's silo to hide its value. The summons in a 661 filing prevents this legally. Once served, those assets are frozen in place. This leads us to the most labor-intensive part of the 1,000-word deep dive, the preliminary declaration of disclosure. In a rural 661 filing, you cannot simply say we own a farm and 2 trucks. You have to be granular. You will be using forms like the Schedule of Assets and Debts and the Income and Expense Declaration. Imagine Sarah and Thomas, a couple in rural Ohio. They have a family farm, a small side business selling artisanal goods online, and 3 vehicles. Sarah, who is handling the 661 paperwork, must list every single asset. This includes the obvious like the 120 acres of land, but also the obscure. In 2026, rural assets often include digital properties. Does the farm have an active social media following that generates revenue? Is there a YouTube channel showing their homesteading life? Does Thomas have a wallet with cryptocurrency? Under the 661 model, if Sarah leaves out even a small digital account, Thomas could return to court 5 years later and claim she committed fraud, potentially entitling him to 100% of that omitted asset. The Income and Expense Declaration is where many rural residents struggle because their income is seasonal. If you are a farmer or a seasonal contractor, your income in July looks nothing like your income in January. Historical trends in 2026 show that the courts are becoming more sophisticated in looking at 3-year averages, rather than just the last 2 pay stubs. You must provide a comprehensive look at your gross and net income. This involves looking at tax returns from 2024 and 2025, factoring in agricultural subsidies, and accounting for the high cost of fuel and supplies in 2026. If you overstate your income, you might end up paying more in support than you can afford when the crop fails. If you understate it, you risk a perjury charge or an overturned judgment. Step by step, the 661 process requires you to serve these disclosures on your spouse. This is not filed with the court immediately. It is an exchange of information that proves both parties are acting in good faith. Once served, you file a declaration regarding service of declaration of disclosure. This tells the judge that the exchange has happened. Why is this so important for a viral level understanding of the law? Because in an uncontested 661 case, the judge is looking for a reason to say yes to your agreement. If the judge sees that you both shared your financial lives transparently, they are much more likely to sign off on your final judgment without requiring you to appear in court. Let's look at the concept of the summary dissolution as a potential outcome. This is the streamlined version of the 661 process for couples who meet very specific criteria. Imagine a young couple in rural Nebraska. They have been married for 3 years, they rent their home, they have no children, and their total community property is worth less than $50,000. They can use the summary dissolution path, which is essentially a joint petition. Both sign the same paper. There is no need for a summons or a formal service of process, and after a 6-month waiting period, they are automatically divorced. However, in 2026, very few rural couples qualify for this because land values have pushed most people over the $50,000 asset limit. Even a small plot of inherited land can disqualify you from the summary path, forcing you back into the standard 661 dissolution track. The 30-day window is the next critical milestone. After the petition and summons are served, the respondent, the other spouse, has 30 days to file a response. In a 661 uncontested scenario, the respondent does nothing. They deliberately allow the 30 days to pass. On day 31, the petitioner files a request to enter default. This is a powerful move. It essentially says the other person agrees with everything I put in my petition, or at least they aren't going to fight it. But there is a twist that we are seeing more often in 2026 rural cases, the default with agreement. This is where you have a written, notarized contract signed by both people, and you submit it along with the default paperwork. This is the gold standard for a clean break. It gives you the privacy of a private contract with the enforcement power of a court order. But what happens when the assets are complicated by 2026 economic realities? We are seeing a surge in rural debt. High interest rates have made farm equipment loans and land mortgages more burdensome. In your 661 filing, you must categorize debt as either separate or community. If you took out a loan to buy a tractor during the marriage, that is community debt. If your spouse ran up a secret credit card for a hobby, you might argue that is separate debt. However, historical trends show that if the debt was used for any family benefit, the court will likely split it 50-50. As we conclude this deep dive into the mechanics of filing and disclosure, you might be thinking that the paperwork is the hardest part. But for many rural families, the financial split is only half the battle. There is a much more emotional and complex layer that we haven't touched on yet. One that can derail a 661 filing faster than a missing signature. In the next part, we are going into the heart of the rural family, the children. How do you handle custody and child support when the nearest school is 40 miles away, and the traditional 50-50 schedule is physically impossible? And what about the hidden asset that is currently causing more rural divorce battles in 2026 than land or money? We are talking about water rights and mineral rights, the invisible wealth under your feet that most people forget to put in their disclosure forms until it is too long. If you missed this, you might be handing over a fortune without even knowing it. Water rights are the invisible gold of 2026, and in a rural divorce 661 filing, they are often the most overlooked asset that leads to post-judgment litigation. To understand the gravity of this, we have to look at the legal doctrine of prior appropriation, which governs most of the Western United States. This principle, often summarized as first in time, first in right, means that the person who first diverted water for a beneficial use has a senior right over those who came later. In a marriage, if the family ranch was acquired during the union, those water rights are typically considered community property or marital assets. However, if the land was inherited by one spouse, but the water rights were improved or expanded using marital funds or labor during the last decade, the characterization of that asset becomes incredibly murky. Imagine a rancher named James in rural Colorado. James inherited 600 acres of scrubland from his grandfather, but during his 15-year marriage to Sarah, they invested heavily in modern irrigation systems and secured new permits to draw from a local aquifer. In 2026, as they navigate an uncontested 661 process, James assumes the land is his separate property. He lists the land on his schedule of assets, but fails to specifically disclose the senior water rights associated with the new permits. This is a critical error. Historical trends in 2025 and 2026 show that water rights can be valued at 3 to 4 times the value of the actual dirt they sit on, especially as droughts persist. If Sarah signs off on the divorce without a professional valuation of those rights, she is potentially walking away from a 7-figure asset. Under the 661 disclosure rules, Sarah could return to court years later, claiming James committed a breach of fiduciary duty by failing to disclose the true value and nature of the water permits. The potential outcome is a judge-set-aside order that reopens the entire financial settlement, costing both parties a fortune in new legal fees. Step by step, when you are filling out your 661 disclosure forms in a rural area, you must look beyond the property deed. You need to pull the records from your state's Department of Water Resources. You must identify the permit numbers, the priority dates, and the volume of acre-feet allowed. You must also determine if the water is appurtenant to the land, meaning it stays with the dirt, or if it is a shares-based system in an irrigation company, which can be sold off separately. In 2026, we are seeing savvy spouses in rural Nevada and California negotiate for the water rights while letting the other spouse keep the house, knowing that the water is the true appreciating asset. Then there is the issue of mineral rights and the 2026 energy boom. Across the American South and the Midwest, the transition to green energy has created a massive market for lithium mining and carbon sequestration rights. Many rural families own the surface rights to their land, but don't realize their mineral estate was severed decades ago. Conversely, some families own the minerals but have no active leases. In a Divorce 661 scenario, the temptation is to ignore what you can't see. But imagine if you live in a county in Arkansas where a major tech conglomerate announces a new lithium extraction project 3 months after your divorce is finalized. If you didn't address the mineral estate in your settlement, you are entering a legal gray zone. Case studies from the early 2020s show that when mineral wealth is discovered post-divorce, the litigation that follows is some of the most aggressive in the country. You must perform a title search to confirm if your mineral rights are unified or severed, and you must list them as a line item on your disclosure forms, even if you currently value them at zero. This acts as a legal shield, proving you didn't hide the asset. Transitioning from assets to the most sensitive topic, child custody in the rural context. The standard 50-50 custody model that works in a suburb, where mom lives 5 minutes from dad and the kids walk to school, is often physically and financially impossible in rural America. In 2026, the cost of fuel and the sheer distance between residences have forced a shift in how 661 agreements are drafted. We call this the distance barrier. Imagine a nurse named Emily who lives in a small town with the only regional hospital, and her ex-husband Mark, a logger who lives 55 miles away up a mountain road that is often impassable in the winter. A traditional week-on week-off schedule would mean their 8-year-old child spends over 10 hours a week in a car. In 2026, we are seeing a rise in block scheduling. Instead of frequent exchanges, rural parents are opting for a 2-2-5-5 or even a month-on-month off rotation to minimize travel. However, this creates a new problem: school stability. In many 661 filings, we now see a designated educational parent. One parent is designated as the primary for school residency purposes to ensure the child isn't switching districts every other week. Another trend is the right of first refusal, but with a rural twist. In a city, this means if you are busy for 4 hours, the other parent gets the kids. In a rural area, we are seeing this extended to 24 or 48 hours because the logistics of a 2-hour round trip for a short visit are simply not practical. Child support in these communities also requires a deep dive into seasonal economics. Many rural residents work in agriculture, timber, or seasonal tourism. Their income in October might be $10,000, but their income in February might be zero. If you use a standard state calculator based on a single month's pay stub, you are setting yourself up for failure. Historical trends show that rural child support orders have a 30% higher rate of default because they are too rigid. In 2026, sophisticated 661 agreements use fluctuating income orders or Smith-Ostler provisions. These are court orders where a base amount of support is set at a low, sustainable level, but a percentage of any seasonal bonuses or harvest profits is paid as additional support when the money actually arrives. This protects the payer from going into arrears during the off-season and ensures the children benefit from the high-income months. Furthermore, we must discuss in-kind support. In rural communities, it is common for a parent to provide a side of beef, a cord of wood, or free labor on the family farm in lieu of some cash support. While this works on a handshake, it is a disaster in a 661 legal filing. The court does not recognize a side of beef as a legal substitute for a $500 monthly obligation, unless it is explicitly written into the judgment as a non-cash credit. Without this detail, the person providing the meat is still legally on the hook for the cash, and the state can intercept their tax returns or suspend their driver's license for non-payment. As we wrap up this exploration of assets in custody, you can see that the 661 process is not just about filling in the blanks. It is about translating your rural reality into a language the court understands. But there is a darker, more complex side to this that we haven't touched on yet. What happens when the land you live on isn't just yours, but is tied up in a family trust or a partnership with your in-laws? This is the inherited property trap, and in 2026, it is the #1 reason why simple uncontested divorces turn into decade-long battles. If you are living in a house built on your father-in-law's land, do you actually own anything? And how do you handle the community reputation when the person you are divorcing is the daughter of the town's biggest employer? We are diving into the social and legal minefield of rural power dynamics in Part 4. You won't want to miss the specific strategy for protecting your reputation when the local grapevine is working against you. The inherited property trap is the single most common reason a seemingly simple divorce 661 filing in rural America turns into a multi-year legal siege. In 2026, we are seeing a massive transfer of generational wealth as older landowners pass their estates to their children. But when that child is married, the line between what belongs to the family and what belongs to the marriage becomes dangerously blurred. To understand this, we have to look at the legal concept of transmutation. This occurs when an asset that was once separate property, like a parcel of land inherited by one spouse, is legally transformed into community or marital property. Imagine a man named Caleb in rural Tennessee. In 2021, Caleb inherited 80 acres of prime timberland from his grandmother. At the time, the land was worth approximately $400,000. Caleb was already married to his spouse, Megan, Over the next 5 years, they used Megan's salary from her job at the regional hospital to pay the property taxes and to clear a site for a new home. They took out a construction loan together, both signing the mortgage to build a $300,000 modern farmhouse. Now in May 2026, as they attempt a Divorce 661 filing, Caleb assumes the land is his because his grandmother's name was on the original deed. Megan, however, argues that the land has been transmuted. Historical trends in 2026 family law show that the act of taking out a joint mortgage or using community funds, like a paycheck earned during the marriage, to improve separate property can give the other spouse a pro rata interest in that property. This is often calculated using what experts call the Moore-Marsden formula. Step by step, the court looks at the value of the property at the date of marriage, the amount of community funds used to reduce the principal of the loan, and the total appreciation of the property during the union. If Caleb and Megan cannot agree on this calculation in their uncontested 661 paperwork, the judge will not sign the judgment. They will be forced out of the streamlined process and into a courtroom where a forensic accountant will charge $300 an hour to do the math for them. In a rural area where the nearest forensic accountant is 3 counties away, this is a financial disaster. Then there is the issue of the third-party joinder, which is the legal equivalent of a hand grenade in a small town. This happens when the assets of a marriage are so intertwined with the assets of the in-laws that the in-laws must be legally joined to the divorce case. Imagine a scenario where a couple, let's call them Sarah and Jackson, live in a house that was built on land owned by Jackson's parents. There is no formal lease, and the parents paid for the materials while the couple provided the labor. In 2026, Sarah wants her share of the equity in the house she spent 4 years building. But because the land is in the parents' names, Sarah's attorney might file a joinder to bring the parents into the lawsuit as third-party defendants. In a rural community, this is the ultimate social taboo. It effectively sues the grandparents of your children. The 661 process is designed to avoid this by encouraging a private settlement, but if the in-laws refuse to acknowledge the spouse's contribution, the case exits the 661 track and enters a high-stakes litigation phase that can destroy family relationships for decades. This leads us directly into the rural power dynamic of reputation management. In a metropolitan area, you can disappear into the crowd. In a town of 2,000 people, the local grapevine is the primary source of information, and in 2026, that grapevine is amplified by local Facebook groups and neighborhood apps. If you are the spouse who is seen as the outsider or the one breaking up a legacy family, the social consequences can be immediate. We have seen case studies where a spouse's business was boycotted, or they were excluded from community organizations simply because of the narrative surrounding their divorce filing. The 661 strategy for reputation management is known as the neutral information strategy. Step by step, this involves a coordinated, shared statement between both spouses. Instead of letting the town wonder why the sheriff was at the house or why the moving truck was there, the couple agrees on a specific bland narrative. We have decided to move in different directions but remain committed to our children and our community. By filing an uncontested 661, you keep the specific allegations, the why behind the split, out of the public record. In many rural counties, the local newspaper still publishes a list of new court filings. A contested divorce with multiple hearings creates a trail of public records that anyone can read at the courthouse. An uncontested 661 filing usually results in a single private judgment that summarizes the end result without airing the dirty laundry. Another critical factor in 2026 is the valuation of the family business's goodwill. In rural America, a business is often valued not just by its equipment or its bank account, but by its reputation. Think of a local veterinarian or a beloved hardware store owner. If you are the spouse of that business owner, you are entitled to a portion of the enterprise value, which includes professional goodwill. However, calculating the value of a person's reputation in a small town is incredibly subjective. Historical trends show that rural business owners often try to claim the business has zero value because it's just them working. But if that business produces a steady stream of income that supported the family for 20 years, the 661 paperwork must reflect a fair market value. If you undervalue the business to keep the peace, you may find yourself in 2027 or 2028 unable to qualify for a loan because you walked away from your largest marital asset. The 2026 economic landscape adds a final layer of complexity: the role of the family trust. Many rural families are moving their land into irrevocable trusts to protect against estate taxes and nursing home costs. If the land you live on is in a trust controlled by your spouse's siblings or parents, your 661 filing faces a massive hurdle. You may have no legal right to the land, but you may have a right to the increase in value or the income generated by the trust during the marriage. This requires a specialized look at the trust documents, which are often held secretly by the family patriarch or matriarch. As we conclude Part 4, we have seen how land, family, and reputation form a tripod that holds up rural life. When one leg of that tripod is cut by a divorce filing, the whole structure can collapse. But even if you navigate the land and the in-laws, there is one final massive hurdle that determines whether you will thrive or just survive after the divorce. We are talking about the changing face of spousal support in 2026. With the rise of remote work in rural areas and the fluctuating price of commodities, the old way of calculating alimony is dead. In the next part, we are going to break down how to calculate a sustainable support plan that won't bankrupt the payer but won't leave the receiver in poverty. We will also reveal the one specific clause in a 661 agreement that can stop your ex-spouse from coming back for more money 5 years down the road. If you don't get this clause right, you are never truly finished with your divorce. The specific clause that serves as the ultimate shield in a Divorce 661 agreement is the waiver of the court's jurisdiction to award or modify spousal support. In legal circles, this is often referred to as a Section 4336 termination or a non-modifiable stay. If you do not include this specific language, your legal relationship with your ex-spouse is essentially on life support for years, or even decades to come. In 2026, the economic landscape of rural America has made this clause more vital than ever before. Historically, spousal support, or alimony, was designed to provide for a spouse who sacrificed their career to maintain the home or farm. But in 2026, the rise of high-speed satellite internet and remote work has fundamentally shifted the earning capacity in small towns. Imagine a case study involving a couple named David and Maria living in a rural county in Nebraska. David operates the family soybean farm, an operation that has seen massive price volatility due to international trade shifts in early 2026. Maria, however, spent the last 4 years working remotely as a senior project manager for a technology firm based in Austin, Texas. In the old rural model, Maria might have been viewed as the dependent spouse. In 2026, Maria is actually out-earning David's net farm income 3-to-1. If David and Maria use a standard online divorce template that doesn't account for this reversal of roles, David might inadvertently waive his right to support, or Maria might leave the door open for David to sue her for support 5 years from now if the soybean market crashes further. In a Divorce 661 masterclass, the step-by-step approach to spousal support begins with the distinction between temporary and permanent support. Temporary support is often calculated using a computer program like Decimaster or a state-specific formula. It is meant to maintain the status quo while the divorce is pending. However, in a rural 661 uncontested filing, you are often moving straight to the permanent support phase. This is where the long-term factors of the family law code come into play. These factors include the marketable skills of the supported party, the time and expense required for that party to acquire education or training, and the extent to which the supported party's earning capacity was impaired by periods of unemployment during the marriage. In 2026, we are seeing a trend called the vocational evaluation. If one spouse claims they cannot work or can only earn minimum wage at the local general store, the other spouse can request an expert to evaluate their potential in the remote job market. Because of the 2026 workforce shift, a spouse with a high school diploma in a remote area now has access to thousands of entry-level digital roles that didn't exist a decade ago. A 661 agreement should reflect this reality. Instead of a permanent check, many rural couples are opting for a step-down support plan. For example, Maria might pay David $2,000 a month for the first year while he adjusts the farm's business model, $1,000 a month for the second year, and then support terminates forever on a specific date in 2028. But here is where the trap lies. In many jurisdictions, if the marriage lasted longer than 10 years, it is considered a marriage of long duration. In these cases, the court historically keeps jurisdiction over spousal support indefinitely, unless there is a written agreement to terminate it. This means that in 2032, if David has a medical emergency or the farm goes into bankruptcy, he could potentially drag Maria back into court to ask for support again, even if they haven't spoken in years. To prevent this, your 661 judgment must include a clear, unambiguous waiver. It must state that both parties have been advised of their rights, that they understand the court's power to award support in a long-duration marriage, and that they are forever waiving that right and terminating the court's jurisdiction to make any such award in the future, regardless of any change in circumstances. Another critical element of the 2026 Rural Support Strategy is the Smith-Osler provision, which we touched on previously but must now expand upon for those with variable incomes. If you are a rancher, a logger, or a seasonal contractor, your base salary might be low, but you may have a high-earning month once a year. A 661 agreement can be structured so that the monthly support is based on the low-earning months, but a percentage of any income above that base, such as a harvest bonus or a timber sale, is paid out as a supplemental support payment. This ensures that the payer isn't crushed by a high monthly obligation during a lean winter, while the receiver still gets a fair share of the family's peak productivity. Data from late 2025 shows that 42% of rural support orders end up in arrears because the payers feel the amounts were calculated using urban cost of living standards that don't apply to them. In a 661 filing, you have the power to customize these numbers. You can factor in the reality that your housing costs are lower but your transportation and fuel costs are significantly higher than someone living in a city. You can also include credits for direct payments. For example, if the payer continues to cover the family's health insurance or the mortgage on the marital home until it is sold, those payments should be explicitly credited against the spousal support obligation in the judgment. We also have to discuss the Gavran warning. In 2026, judges are increasingly including this warning in 661 judgments. It is a formal notice to the supported spouse that they must make a good faith effort to become self-supporting within a reasonable period of time, usually half the length of the marriage. If they fail to do so, the court can later reduce or terminate the support. For the person paying support, ensuring this warning is in the final 661 paperwork is a vital layer of protection. It creates a legal expectation that the other person will eventually stand on their own 2 feet. As we move through the complexities of support and financial finality, we must also address the actual mechanics of the judgment itself. Many people think that once they sign the papers they are divorced. This is a dangerous misconception. In rural counties with backlogged courts, a signed agreement is just the beginning of the waiting period. There is a specific document called the Notice of Entry of Judgment that is the true finish line. Until that document is stamped and mailed by the court clerk, you are still legally married. This means if you win the lottery or, more commonly in rural areas, if you receive a significant inheritance the day before that judgment is entered, that asset could still be considered community property. The 2026 rural divorce seeker must be a master of the timeline. We've covered the filing, the disclosure, the custody logistics, and the support waivers. But there is a technical phase that causes more 661 filings to be rejected by the court than anything else. We are talking about the judgment checklist and the specific way rural court clerks are now scrutinizing self-represented paperwork. If your font is too small, if your captions don't match exactly, or if you forgot to include a self-addressed stamped envelope, your case can be thrown out after 6 months of waiting. In the next part, we are going to walk through the exact steps of the judgment package. We are also going to reveal the specific trap regarding the 6-month waiting period that causes thousands of people to accidentally commit bigamy when they try to get remarried too soon. You need to know exactly which date on your paperwork is the one that actually matters for your freedom. The technical threshold you are crossing right now is known as the judgment entry phase. In the world of Divorce 661, this is where the theoretical agreement becomes an enforceable mandate of the state. However, in 2026, rural courthouses are operating under a unique and often frustrating duality. While many urban centers have fully transitioned to automated AI-assisted document review, many rural jurisdictions in states like California, Missouri, and Georgia are using a hybrid system. They are part digital and part legacy paper. This creates a technical minefield that can delay your freedom by months if you do not understand the specific paperwork hierarchy. The most critical document in your judgment package is the FL 180, simply titled Judgment. This is the 2-page form that acts as the cover sheet for your entire future. In a 661 uncontested case, how you check the boxes on this form determines the complexity of your finalization. There is a box for default and a box for uncontested. In 2026, historical trends show that people often check the wrong one, leading to an immediate rejection by the clerk. If you served your spouse and they never filed a response, you are proceeding by default. If you both signed a marital settlement agreement, you are proceeding via an uncontested written agreement. Step by step, you must ensure that every date on this form is historically accurate. The date the court acquired jurisdiction over the respondent is the single most important number on that page. It is usually the date your spouse was personally served or the date they filed a joinder. If that date is missing or incorrect, the entire package is sent back to your rural mailbox with a rejection slip. Imagine a man named Mark living in rural Oregon in June 2026. Mark is a logistics coordinator for a local timber company. He and his spouse separated in late 2025, and Mark served her with divorce papers on January 10, 2026. Mark has read that there is a 6-month waiting period for a divorce to be final. In his mind, he does the math January to July. He assumes that on July 11th, he will be a single man. He has already planned a small ceremony to remarry his new partner in August 2026. Mark spends his weekends filling out the 661 paperwork, thinking he is being diligent. He submits his judgment package in May. However, the rural court clerk in his county is backed up due to a 2025 staffing shortage. The clerk doesn't even look at Mark's file until July. When they do, they find that Mark forgot to include the FL-191, which is the child support case registry form. Even though Mark and his ex-spouse agreed on zero child support, the law in 2026 still requires this form to be part of the package for data tracking purposes. The clerk rejects the filing. Mark receives the rejection in the mail on July 20th. Now Mark is in a panic. He thinks he can just fix the form and be done. But here is the potential outcome that Mark didn't see coming. The 6-month clock is only a minimum. Your marital status does not automatically terminate after 6 months. A judge must sign the judgment, and the clerk must enter it. Because of the rejection, Mark is still legally married on the day of his planned August wedding. If he proceeds with that wedding, he is technically committing bigamy, which can lead to the new marriage being declared void and potentially creating a legal nightmare for his new partner's insurance and inheritance rights. Case studies from 2024 and 2025 show that thousands of rural Americans fall into this trap every year because they confuse the cooling-off period with an automatic expiration date of the marriage. To avoid Mark's fate, you must master the judgment package components. Beyond the FL-180, you have the FL-190, the Notice of Entry of Judgment. In a rural 661 filing, you must provide the court with the original and at least 2 copies of this form, along with 2 self-addressed stamped envelopes. This seems like a minor detail, but in 2026, many rural courts will not even process your file without those envelopes. Why? Because the court budget in small counties does not always cover the postage to mail back your certified copies. If you don't provide the envelopes, your paperwork sits on a desk in a back office until you call to check on it 6 months later. Furthermore, you must consider the Marital Settlement Agreement or MSA. This is the contract that details who gets the house, who gets the debt, and how the retirement accounts are split. In 2026, we are seeing a shift toward incorporating the MSA by reference. This means instead of typing everything onto court forms, you attach your private, notarized contract to the back of the FL-180. However, the language must be precise. It must state that the parties agree that the court shall reserve jurisdiction to enforce the terms of the attached agreement. In rural areas where family land is often at stake, you must also include legal descriptions of the property, not just the street address. You need the township, range and section numbers from the county assessor's records. If you just say the house on Bluebird Lane, the judgment may be unenforceable when you try to sell the land or remove a name from the deed 5 years from now. Another often overlooked step in the 661 deep dive is the restoration of name. If one spouse wants to return to their former or maiden name, this must be requested specifically on the FL-180. In 2026, with the increase in digital identity verification, having a court-ordered name restoration is the only way to quickly update your driver's license, passport, and social security records. If you forget to check this box and the judge signs the judgment, you have to file a separate motion and pay an additional fee later to get your name back. Data from late 2025 indicates that 60% of self-represented 661 filings are rejected on the first attempt due to clerical errors. This is why the masterclass approach requires a double check of every signature. In 2026, some rural courts allow for digital signatures like DocuSign, but many still require wet signatures, meaning ink on paper. If you submit a digital signature to a court that hasn't updated its local rules, your judgment will be rejected. You must verify the local rules of your specific rural county. But what happens if you get all the paperwork right, you have your envelopes ready, and you are waiting for the clerk to stamp your file, but then you realize you can't actually find your spouse? This is the ghosting phenomenon that is currently plaguing rural divorce filings in 2026. People move away for work, they go off the grid, or they simply refuse to engage. If you can't serve them the final papers, your 661 process hits a brick wall. In the next part, we are going to dive into the nightmare scenario of service by publication. We will explain how to convince a judge that you have done a diligent search for a missing spouse, and how to get your divorce finalized, even when the other person is nowhere to be found. We will also look at the specific costs of this process in rural newspapers, which can be surprisingly high in 2026. This is the secret path to freedom for those who are stuck in legal limbo. The phenomenon of the vanishing spouse is not just a plot point for a thriller. In 2026, it is a significant legal roadblock for thousands of residents in rural communities across the United States. Whether a spouse has moved for work in a distant oil field, transitioned to a transient digital nomad lifestyle, or simply walked away into the vastness of the American interior, their absence creates a state of legal paralysis. You cannot move forward with a Divorce 661 filing if you cannot prove that the other party has been given their constitutional right to due process. This brings us to the most complex and scrutinized procedural path in the family law system: service by publication. Imagine a man named Jacob who lives in a small township in rural Montana. It is July 2026. Jacob's wife, Leanne, left 3 years ago, taking only a suitcase and leaving no forwarding address. Jacob has remained in their family home, which sits on 40 acres of timberland. He wants to move forward with his life, perhaps even sell the property to fund a new venture, but because Leanne's name is on the deed and the marriage is still legally intact, he is trapped. He cannot use the standard 661 process of personal service because he doesn't know where she is. He has tried calling her old number, which is disconnected, and messaging her social media accounts, which have been dormant since 2024. Jacob's path to freedom now requires him to convince a judge that Leanne is legally a ghost. The first step in this deep dive is the declaration of diligent search. In 2026, a judge will not simply take your word for it that your spouse is gone. You must provide an exhaustive step-by-step account of your efforts to find them. This is where many rural residents fail. They think a few phone calls to relatives are enough. Historical trends in 2025 and 2026 show that courts now expect a digital age search. Jacob must document that he has contacted the last known employer, searched the voter registration records in the last 3 counties where Leanne lived, and performed a search of the Department of Motor Vehicles. But it goes deeper. Jacob must also perform a search of the Department of Defense Manpower Data Center to ensure Leanne is not currently serving in the military, as the Service Members Civil Relief Act provides specific protections against default judgments for those on active duty. He must contact the U.S. Post Office to request a forwarding address search, a process that involves specific forms and a small fee. In 2026, the court also expects a search of the Social Security Death Index and local jail or prison rosters. If Jacob skips even one of these steps, his application for order for publication will likely be denied. The court views service by publication as the absolute last resort because it is the least likely way to actually give someone notice. Once Jacob has compiled this mountain of evidence, he files the application for order for publication. This is a formal request asking the judge to allow him to notify Leanne of the divorce by running an advertisement in a newspaper. If the judge is satisfied with Jacob's diligence, they will sign the order. Now, Jacob enters the specific and often expensive world of rural legal notices. In rural America in 2026, the local newspaper is often struggling. Many have moved to weekly-only print cycles or have consolidated with larger regional publications. However, the law still requires the notice to be published in a newspaper of general circulation in the area where the respondent was last known to reside. Case studies from 2025 show that the cost for these legal notices has skyrocketed as newspapers rely more heavily on legal advertising for revenue. Jacob might find himself paying between $450 and $900 just to run a small print notice once a week for 4 consecutive weeks. Step by step, the publication process works like this. The notice must include the names of the parties, the case number, the name of the court, and a clear statement that a petition has been filed. It must warn the respondent that they have 30 days from the date of the last publication to file a formal response, or the court will proceed without them. Jacob must obtain an affidavit of publication from the newspaper's clerk once the 4 weeks are up. This affidavit is the golden ticket. It is the proof of service that allows the 661 process to finally move into the default phase. But here is the high-stakes risk that we must address in this masterclass: the set-aside. Imagine if 6 months after Jacob gets his final 661 judgment and sells the timberland, Leanne suddenly reappears. If she can prove that Jacob knew where she was all along, perhaps he had her current email address but didn't disclose it to the court, or if she can show that he didn't actually perform the diligent search he claimed, she can file a motion to set aside the judgment. In 2026, historical trends show that courts are increasingly sympathetic to these motions, if there is even a hint of extrinsic fraud. Extrinsic fraud is a legal term for when one party's actions prevent the other party from having their day in court. If the judgment is set aside, the divorce is voided. Jacob could find himself still married, potentially liable for the proceeds of the land sale he already spent, and back at square one of the legal process. This is why the 661 principle of absolute transparency is non-negotiable, even when your spouse is missing. For those who do complete the publication process honestly, the potential outcome is a true default. In a standard 661 uncontested case, you and your spouse have reached an agreement. In a default by publication case, the judge has to make decisions on your behalf regarding the division of property and debts, because there is no agreement. In Jacob's case, the judge will look at the 40 acres. Since Leanne is not there to testify, the judge will rely on Jacob's schedule of assets and debts. If Jacob claims the land is his separate property, he must provide the 2026 equivalent of a paper trail: inheritance records, deeds, or bank statements showing separate funds were used. The judge in a rural county will also be sensitive to the community impact. If there are children involved, the judge will likely order a custody arrangement that reflects the reality of the situation, giving Jacob sole legal and physical custody, but perhaps reserving the issue of visitation should Leanne ever return. This reservation of jurisdiction is a common feature of 2026 rural judgments. It leaves the door cracked open for future modifications while giving the present-day parent the legal authority to enroll children in school or obtain medical care without the missing parent's signature. As we conclude this deep dive into the ghosting and publication phase of rural divorce, you can see that the path is grueling but necessary for those stuck in legal limbo. It is a process that rewards the meticulous and punishes the shortcut takers. But even if you have a spouse who is present and accounted for, and even if you've completed your diligent search and your paperwork is perfect, there is a technical monster waiting for you at the end of the 661 track. We are talking about the Qualified Domestic Relations Order, or QDRO. If you or your spouse has a pension, a 401k, or a retirement account through a rural employer like a school district, a utility company, or a government agency, your 661 judgment is not enough to split that money. Many people walk away from their divorce thinking their retirement is settled, only to find out 20 years later that they can't access a dime of their ex-spouse's pension because they missed one specific, highly technical document. In Part 8, we are going into the mechanics of the QDRO. We will show you why this is the most common point of failure for rural retirees in 2026, and how to ensure you don't lose your golden years to a clerical oversight. Stay with us because this is where the real money is won or lost. The Qualified Domestic Relations Order, or QDRO, is the most dangerous ghost in the machine of a Divorce 661 filing. Most rural Americans walk out of the courthouse with their final judgment in hand, believing that because the judge signed a paper saying they get half of their spouse's retirement, the money is already theirs. In reality, that judgment is often completely worthless in the eyes of a pension plan administrator. In 2026, as the first wave of Gen X rural workers begins to eye retirement alongside the tail end of the boomer generation, the stakes for these accounts have never been higher. If you do not execute a QDRO properly, you are essentially leaving your future financial security to chance. To understand why this is such a critical point of failure, we have to look at the Employee Retirement Income Security Act, or ERISA. This federal law dictates that retirement plan administrators cannot simply give money to a non-employee spouse based on a state court divorce decree. They require a specific separate court order that meets every single one of their technical internal requirements. Imagine a woman named Linda in rural Michigan. She was married to Gary for 25 years. Gary worked for the Regional Power Cooperative, a major employer in their corner of the state, and he has a significant defined benefit pension. In their 661 uncontested agreement, Gary and Linda agreed to split the pension 50-50 based on the years they were married. They filed their paperwork, the judge signed the judgment, and Linda moved into a small rental, waiting for the day she could start drawing her share of Gary's retirement. 5 years pass. It is now 2031. Gary reaches retirement age and begins drawing his pension. Linda calls the power company to ask when her checks will start arriving. The plan administrator tells her they have no record of her interest in the plan. Linda faxes over her divorce judgment. The administrator sends back a cold, formal letter. This judgment does not constitute a qualified domestic relations order under ERISA guidelines and our plan summary description. Until a valid QDRO is served on us, we will continue to pay 100% of the benefit to Gary. Linda then finds out that Gary has already spent the first few months of the pension and, more importantly, Gary has remarried and designated his new wife as the survivor beneficiary. Because Linda didn't secure her QDRO in 2026, she may have permanently lost her right to survivor benefits, meaning if Gary dies, her income stream vanishes forever. This is a scenario we see in historical trends across the Midwest and the South. The QDRO process is a multi-step marathon that must be run alongside the 661 process. Step by step, the first move is the joinder. In many jurisdictions, you must legally join the retirement plan as a party to your divorce case. This puts the plan on notice that a claim is being made. In 2026, many rural pension plans, especially those for teachers, firefighters, and utility workers, have strict joinder requirements. If you don't join them, they won't even talk to you about the account's value. The second step is the drafting. This is not a form you can just download from a generic website. Every plan has its own manual. Some plans prefer a separate interest QDRO, which carves out a piece of the pension and gives the non-employee spouse their own separate account that they can control. Others only allow a shared interest QDRO, where the non-employee spouse simply receives a portion of the check whenever the employee decides to retire. In a rural context where the employee spouse might want to keep working the farm or the shop until they are 80, a shared interest QDRO can be a trap for the other spouse who needs the money now. In 2026, we are also seeing a massive complication with the valuation of these accounts due to the interest rate shifts of the mid-2020s. If you have a 401k or a defined contribution plan, the value is easy to see on a statement. But if you have a defined benefit pension, the present value is a mathematical projection. If you are the spouse keeping the house and giving up your right to the pension, you must ensure the valuation is accurate. Historical trends show that in rural communities, couples often trade the equity in the family home for the pension rights. For example, if the house has $200,000 in equity, the husband might keep the house while the wife keeps the rights to $200,000 of his future pension. But if that pension is actually worth $500,000 in today's money, the wife is making a catastrophic financial mistake. Another layer of the 2026 QDRO deep dive is the issue of Gilmore rights. This is a legal principle that allows a non-employee spouse to start receiving their share of the retirement benefits once the employee reaches their earliest retirement age, even if the employee chooses to keep working. In a 661 agreement, you must specifically address whether you are invoking or waiving your Gilmore rights. For a rural spouse who has moved into town and has higher cost of living expenses, being able to draw on that retirement while the ex-spouse is still out in the fields can be the difference between stability and poverty. Then there is the nightmare of the missing survivor benefit. This is the clause that ensures that if the employee spouse dies first, the non-employee spouse continues to receive their share. Plan administrators in 2026 are increasingly strict about this. If the QDRO does not explicitly name the ex-spouse as the surviving spouse for the purposes of the plan, the benefit often defaults to the current spouse or the estate. Case studies from 2024 and 2025 highlight dozens of instances where ex-spouses lost millions in aggregate benefits because of the omission of a single paragraph regarding survivor elections. Furthermore, we must discuss the tax implications of the QDRO. Under IRS Section 72T, a QDRO allows for a one-time distribution from a qualified plan to an ex-spouse without the standard 10% early withdrawal penalty, though ordinary income tax still applies. In rural areas where cash flow is often tight during a divorce, this can be a vital source of liquidity to pay off marital debts or secure new housing. However, if you simply withdraw the money without a QDRO in place, the IRS will hit you with that 10% penalty and the full tax bill, potentially wiping out a third of the asset immediately. The 2026 rural divorce seeker must also be wary of the small employer 401k. Many small agricultural businesses or local retail chains use third-party administrators for their 401ks. These administrators often charge a fee to review and process a QDRO, sometimes ranging from $500 to $1,200. In your 661 settlement, you must decide who pays that fee. If you don't specify, and the plan refuses to process the order until the fee is paid, your asset split remains in limbo. As we conclude this masterclass on the QDRO, it should be clear that the finish line for your divorce is not when the judge signs the judgment, but when the plan administrator sends you a letter saying your QDRO has been qualified and your account has been established. But even with the money secured, there is one final, overarching challenge that determines whether a Divorce 661 is truly successful. It's the transition from a shared rural life to an independent one. How do you handle the taxes on the property you just split? What happens to your credit score when the joint agricultural loans are closed? And how do you protect yourself from the hidden debts your spouse might have run up before the split? In Part 9, we are looking at the post-divorce financial reset. We will break down the exact steps to untangle your credit, protect your new assets, and ensure that the 2026 tax season doesn't turn into a second legal battle with your ex. The paperwork is done, but the protection of your new life is just beginning. The financial ghost of your marriage does not simply vanish the moment a judge signs your Divorce 661 judgment. In fact, for many residents in rural America, the most treacherous financial hurdles appear in the 18 months following the finalization of the case. While your legal status has changed from married to single, your financial identity is often still tethered to your former spouse through a web of joint credit accounts, shared tax liabilities, and intertwined property titles. To truly achieve the independence that the 661 process promises, you must execute a comprehensive post-divorce financial reset. We begin with the immediate crisis of credit management. In rural communities where large-scale purchases like four-wheel drive trucks, tractors, and livestock trailers are a necessity of life, joint credit is the standard operating procedure. Imagine a woman named Becky living in a rural county in Kentucky in late 2026. During her 15-year marriage, she and her husband maintained a joint line of credit at the local agricultural bank to fund their cattle operation. Even though their 661 judgment explicitly states that her ex-husband is responsible for the remaining $45,000 on that line of credit, the bank is not a party to the divorce. Under the principle of joint and several liability, the bank still views Becky as 100% responsible for that debt. Historical trends in 2026 show that if Becky's ex-spouse misses just 2 payments while trying to restructure the farm, Becky's credit score could plummet by over 100 points overnight. This could prevent her from securing a lease on a new home or obtaining a loan for her own independent business. Step by step, the first move in a post-divorce reset is to contact every creditor and formally close joint accounts. You cannot simply stop using them. You must request a letter of closure from the creditor. If a balance remains, you should explore the potential outcome of refinancing that debt into a single name. If the ex-spouse cannot qualify for a solo loan, Becky must remain hypervigilant, monitoring the account through 2027 until the balance is zero. Turning our attention to the 2026 tax season, the complexities for rural families are significantly magnified. The Internal Revenue Service operates independently of state court orders. Even if your 661 agreement says you get to claim the children as dependents, the IRS generally grants the dependency exemption to the custodial parent, the one with whom the child lived for more than half the year. To align your rural reality with federal law, you must use IRS Form 8332. This form allows the custodial parent to release their claim to the exemption to the non-custodial parent. Without this specific form, a 2026 tax audit could result in the IRS stripping the exemption from the non-custodial parent, regardless of what the divorce papers say. Furthermore, we must address the head of household filing status. In 2026, the tax benefits of filing as head of household are substantial, but the criteria are strict. You must have paid more than half the cost of keeping up a home for the year, and had a qualifying person live with you for more than half the year. In a rural 661 scenario where parents might be nesting, moving in and out of the family home while the children stay put, determining who paid more than half the cost of the home becomes a forensic accounting nightmare. Marcus, a rancher in rural Texas, found himself in this exact situation in early 2026. Because he and his ex-wife shared the mortgage payments on the family ranch for the first 7 months of the year, neither technically qualified for head of household status for that filing year. This resulted in a significantly higher tax bill than either had anticipated. The next pillar of the reset is the physical transfer of titles and deeds. In a metropolitan area, this might involve a single condo deed. In a rural community, this involves land, water shares, grazing permits, and brand registrations. Step by step, a 661 judgment is only a roadmap. It is not the vehicle. To remove your ex-spouse from the title of your land, you must file a quitclaim deed or an interspousal transfer deed with the county recorder. In 2026, the fees for these filings in rural counties have increased to fund the digitization of records. If you fail to file this deed immediately, you will face a wall of bureaucracy when you eventually try to sell the land or pass it to your heirs. We must also look at the hidden danger of the indemnity clause. A well-drafted 661 agreement should include a provision where each party agrees to indemnify and hold the other harmless from any debt assigned to them. Imagine if Becky's ex-husband had a secret credit card that Becky didn't know about during the disclosure phase. If the credit card company sues Becky in 2027 for a debt run-up during the marriage, the indemnity clause gives Becky the legal right to sue her ex-husband to recover any money she is forced to pay the creditor, including her legal fees. Without this clause, Becky would be left holding the bag for a debt she didn't even know existed. Estate planning is the final, often forgotten piece of the 2026 financial reset. Most people assume their divorce automatically removes their ex-spouse from their will or life insurance policy. While some states have statutes that revoke such designations upon divorce, many do not. Case studies from 2024 and 2025 reveal tragic instances where life insurance payouts from a deceased rural worker went to an ex-spouse from a decade prior, leaving the current family with nothing. You must manually update your beneficiary designations on every life insurance policy, IRA, 401k, and bank account. You must also draft a new will and power of attorney. If you are injured in a farming accident in 2028 and your ex-spouse is still listed as your medical proxy, they, not your current partner or your siblings, will be the one making life or death decisions on your behalf. As we examine the data on rural post-divorce recovery, we see that those who complete these steps within the first 90 days have a 40% higher rate of financial stability 5 years later. This is not just about paperwork. It is about severing the liability loops that allow a former partner's financial mistakes to become your own. We have looked at credit, taxes, deeds, and estate plans. But there is one final area of the 2026 landscape that is currently causing more post-divorce friction than almost anything else. It is the issue of digital assets and privacy. From shared cloud storage containing 10 years of family photos to passwords for agricultural software and smart home systems on the ranch, the digital entanglement of a rural marriage is profound. If you don't secure your digital borders, your ex-spouse may still have access to your location, your emails, and your financial transactions long after the moving trucks have left. In the final part of this masterclass, we are going to dive into the digital exit strategy. We will also cover the ultimate finality: what to do if your ex-spouse refuses to follow the 661 judgment you worked so hard to obtain. How do you enforce a court order in a small town without spending another $20,000 on a lawyer? We are ending this series with the definitive guide to enforcement, contempt, and the final breath of freedom. Stay tuned for the conclusion. The digital border is the final frontier of your divorce. In 2026, the modern American farm or rural household is more connected than ever before. We are no longer just talking about shared streaming service passwords or family social media accounts. We are talking about integrated smart home systems, GPS-tracked agricultural equipment, and shared cloud accounts that hold every private document and family photo from the last decade. If you have completed your Divorce 661 paperwork but have not performed a digital clean sweep, your ex-spouse still holds a virtual key to your daily life. Imagine a man named Caleb in a rural county in Iowa. It is late 2026. He has finalized his divorce and is living in the family farmhouse while his ex-spouse has moved into a nearby town. Caleb notices that the climate control in his smart barn is fluctuating wildly, or he realizes that his ex-spouse is commenting on private business emails he hasn't shared with anyone. In 2026, this is a common potential outcome of a digital entanglement. Step by step, you must audit your digital footprint. This begins with the hardware. In many rural homes, the satellite or fiber internet service is tied to a single name. If that name is your ex-spouse, they can remotely access the administrative panel to see every device connected to the network and potentially intercept data traffic. You must factory reset your home network and establish entirely new credentials. For rural professionals, this extends to specialized software. If you use a shared account for cattle records, crop insurance, or precision agriculture software like John Deere Operations Center, you are vulnerable. Historical trends in 2025 and 2026 show an increase in digital sabotage during post-divorce conflicts, where one party deletes years of harvest data or revokes access to critical mapping tools. You must document the separation of these accounts in your 661 agreement. If the agreement says the data and the subscription belong to you, you must provide a copy of that judgment to the software provider to revoke the other party's access and change all multi-factor authentication methods to your new, independent device. But what happens when the digital clean sweep is the least of your problems? What if your ex-spouse simply refuses to follow the court order? This is the moment where the 661 dream of an amicable split meets the harsh reality of human nature. In a rural setting, enforcement can feel difficult because of the distance from the courthouse, but the law provides high-stakes tools to ensure compliance. Let's look at the enforcement of a money judgment. Imagine your judgment orders your ex-spouse to pay you a $75,000 equalization payment for your share of the family land by December 2026. December comes and goes, and the mailbox is empty. You do not need to spend $20,000 on a new legal battle. You have the power of the writ of execution. Step by step, you take your signed 661 judgment back to the court clerk and request a writ of execution on Form EJ-130. This document is a directive from the court to the county sheriff. In a rural community, the sheriff's civil division is an essential resource. With this writ, you can perform a bank levy. If you know where your ex-spouse keeps their harvest proceeds or their savings, often a local community bank where the tellers know both of you, the sheriff can legally seize the funds directly from the account to satisfy your judgment. Historical trends show that a single bank levy often suddenly motivates a non-compliant spouse to find the money they claimed they didn't have, especially when their ability to pay local vendors is suddenly frozen. If they do not have a lump sum in the bank, you look at an earnings withholding order. This is the 2026 version of wage garnishment. If your ex-spouse works for a regional hospital, a school district, or a large agricultural firm, you serve this order on their payroll department. Federal and state laws limit how much can be taken, but it ensures a steady stream of payments until the debt, plus the 10% annual interest that most states allow on judgments, is paid in full. Over 5 years, a $75,000 debt can grow significantly, making it a very poor financial decision for the payer to delay. Then there is the issue of the refusal to sign. In rural areas, land transfers are emotional and often tied to family pride. If your ex-spouse is ordered to sign a deed to transfer the family home to you, but they refuse to pick up the pen, you use the eleaser process. This is a specialized motion where you ask the judge to appoint the clerk of the court as an eleaser. Step by step, the clerk then stands in the shoes of your ex-spouse and signs the deed on their behalf. That signature is just as legally valid as if your ex-spouse had signed it themselves. You take that deed to the county recorder, and the property is officially yours. The 661 model anticipates cooperation, but the eleaser process is the fail-safe for when that cooperation evaporates. For non-money issues like refusing to follow a custody schedule or failing to provide court-ordered life insurance, you move to the order to show cause and affidavit for contempt on Form FL-410. This is the nuclear option in family law. Contempt is a quasi-criminal proceeding. You are alleging that the other person had the ability to follow the order but willfully chose not to. If found guilty, the potential outcomes include heavy fines, mandatory community service, and in extreme cases, jail time. In a small town, being served with a contempt motion is a massive reputational blow. It signals to the community and the court that you are a person who does not respect the rule of law. Most people will settle the issue the moment they are served with a contempt hearing date because they do not want to stand in front of a local judge and explain why they defied a direct order. Finally, we must address the social finality of rural life in 2026. Rebuilding your life in a community where everyone knows your history requires a specific kind of resilience. Case studies of successful post-divorce transitions show that the most stable individuals are those who lean into the modular life strategy. They don't try to keep the exact same social circles or the same routines that existed during the marriage. They build new traditions on the land they fought for. They use the transparency of their 661 process as a shield against gossip. When someone at the local diner asks what happened, the answer is simple. We handled it ourselves, the paperwork is finished, and we are both moving forward. You have now completed the 10-part masterclass on Divorce 661 in U.S. rural communities. You have gone from the initial shock of the decision to the filing of the petition, the disclosure of complex assets like water and mineral rights, the logistics of rural custody, the technicalities of the QDRO, and the finality of enforcement. You are now equipped with more knowledge than 95% of the people walking into a family law courthouse today. This knowledge is your power. It is the difference between a divorce that destroys your legacy and one that preserves your future. The 2026 landscape is challenging, but it is also full of opportunity for those who are willing to do the work and follow the law. You have the tools, you have the forms, and now you have the roadmap. Your final breath of freedom is not just a signature on a page. It is the peace of mind that comes from knowing you did it the right way, protected your assets, and secured your family's future. The gate is open. It's time to walk through it.